Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Alexa Kawlewski, a recent graduate of Notre Dame Law School.
Thank you for joining us for another episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it. If you support our work, you can like this podcast and subscribe to our channel on YouTube, Spotify, or wherever else you happen to be listening from. And you can always find out more about what we are up to and support our work at napalegalinstitute.org. One note that we have been trying to highlight, so I figure we do it right on the front end here. Napa Legal's annual nonprofit summit will be on July 22nd in Napa, California. So that's only 2 weeks away. There's still some time to register. We have slots open. It's a one-day formation event for nonprofit leaders, board members, professionals like lawyers who serve nonprofits, basically anyone at all in the religious nonprofit space. It's an awesome day of formation, networking, and so on. I will be there, and I hope to see some of you there as well. So with that, we'll go into our regularly scheduled programming. So we have hit the last of the Supreme Court decisions before the Supreme Court justices hightail it out of DC. That happened last week. So that'll be our third story. We'll cover one of the SCOTUS decisions that is relevant to our work. But we're going to start with a recent lawsuit by Catholic Charities in Michigan over, I say, potential alleged religious discrimination and withholding Medicaid and grant funding. Then we'll go to Maryland and talk about a lawsuit that was brought by a teacher who's essentially refusing to use false pronouns. And then we will finish with the recent Supreme Court decisions. Those are BPJ and Hecox, the two decisions where the Supreme Court upheld the right of states to keep boys out of girls' sports in their school sporting programs. So let's start in Michigan, which there really are some frequent offenders. I feel like I say, let's start in Michigan, let's start in Colorado, let's start in Washington State. These happen a lot. So let's start in Michigan. This is a case involving a Catholic Charities. They serve Ingham, Eaton, and Clinton counties. I hope I pronounced the first one right. It's like a lot of Catholic Charities. They serve a pretty wide array of people in a wide variety of services. So they work with the vulnerable. They've been in Lansing, Michigan since 1968. They provide all kinds of services, healthcare, substance abuse treatment, counseling, financial coaching, legal assistance to the indigent and needy, the things you'd expect a Catholic Charities to do. This Catholic Charities is, glad to hear, overtly religious about their core beliefs, including its adherence to the Catholic Church's teaching on abortion and contraception, which is likely the reason for the current case that we're talking about. It's fuzzy how this organization functioned in Michigan for over 50 years. And then Michigan all of a sudden became aware of the organization's stance on these beliefs. I'm not sure if there was a shift in leadership. I really would just be speculating. But in any event, apparently Michigan became aware and got involved pretty quickly. There was an investigation launched involving this Catholic Charities. There were new policies that were pretty clearly hostile to religion, or at least certain religions. And then Michigan's agency that dispenses Medicaid and some federal block grant funding demanded a meeting with the organization. There were attempts by Catholic Charities to comply with these new policies. And then Catholic Charities, within, I think, a few days of that first meeting, was stripped of various streams of state funding. So the state provided no clear explanation. So we're still kind of basing our thoughts thus far on the complaint that Catholic Charities filed. But the only claim that we have was that the state alleges the organization's internal policies and procedures, whatever those are, were the basis for discontinuing the organization's designation as there are two designations: women's specialty service provider, and I think women's enhanced women's services provider. So there are different classifications that entitle you to different grants and funds. So those were pulled. And then the state further demanded that the organization, Catholic Charities, stop taking new admissions into these women's treatment programs and also develop a plan to transition existing clients to different providers. Admirably, Catholic Charities just said no. They're committed to the people they serve. They refused. They've continued serving people as usual and are covering the costs of the services without the state funding pending the lawsuit. So Alliance Defending Freedom is representing the Catholic Charities. They filed a lawsuit in the Western District of Michigan in federal court. And again, we're only going off what's in the complaint and a couple of brief statements that are public. But the lawsuit alleges that the withholding of funds really can only be motivated by hostility toward the organization's faith. And so the complaint alleges violations of the First Amendment, the 14th Amendment, as well as some federal statutes that protect faith-based providers that serve in these programs. So just from the top, the organization's mission statement is what you would expect of a faith-based organization, right? Rooted in Jesus' love and guided by the teachings of the Catholic Church. We are dedicated to serving those in need through the spiritual and corporal works of mercy. We promote respect for the dignity and sanctity of human life and strive to strengthen families, nurturing the compassion and justice central to our faith. Pretty run-of-the-mill for a religious organization. Shouldn't be particularly controversial. They're certainly not the only faith-based organization that serves women. So there's a lot here in the law. I'm going to take a little bit of time to just talk about the requirements from what I can glean from this complaint for these programs. And then we'll talk about where I think this is probably going to go. So the complaint alleges that Catholic Charities meets the requirement for these two programs, the Women's Specialty Services and Enhanced Women's Services programs. And so the complaint alleges withholding the funding without a solid legal reason violates federal law. The program requirements in the first one, the Women's Specialty Services program, expressly do not include requiring providers to directly process or refer for, offer or refer for abortions or contraception. The other program, the Enhanced Women's Services requirements, they do recommend that programs promote, quote, the effective use of contraceptive methods through appropriate use of family planning methods. So from what I've seen, that's the only, it's not even a requirement, but recommendation in any of these programs that could butt up against Catholic Charities' statement on contraception in particular. But the Catholic Charities program claims that they fulfill this requirement. They have counseling programs that teach natural family planning, that counsel on abstinence, in line with Catholic teaching, but fulfilling this at least one way, I think a healthier way of reading, right, an encouragement of the effective use of contraceptive methods to teach people about how to actually, adhere to the natural law and Christian teaching and be open to life while still, acknowledging the difficulties of certain women's circumstances. So it doesn't look like there's anything that they're not complying with that is a requirement of either of these programs. And then further, these federal grant laws include what's called a charitable choice provision that has pretty strict protections for the autonomy of faith-based providers, that basically their faith, their beliefs and practices not be interfered with in their participation in these programs. So it doesn't look like there's any bona fide reason other than religious hostility that I can see that would warrant, a sudden investigation, policy change, and ripping away of funding. But I think time will tell if there's any other reason going on. We haven't seen one yet. So after this investigation into Catholic Charities began, again, the origins of why it happened are kind of mysterious. But Michigan created this new policy meant to probe pretty deeply into the work of religious organizations. Among other things, the new policy mandates that any organizations participating in these programs that are religious disclose any known service limitations related to a number of things: reproductive health, family planning, LGBT issues. So this seems to go beyond what I've seen the federal law actually requires of these religious orgs, especially under that charitable choice provision. And it creates some pretty drastic intrusions into the religious beliefs of these otherwise qualified religious organizations. But that's basically what they wanted. They want you to tell on yourself and say, I mean, obviously I'm paraphrasing, but is there anything in your religious faith that's going to, run afoul of what we want you to do related to abortion, contraception, a host of LGBT issues, and so on? Despite the over-the-top request of this new policy, Catholic Charities actually did attempt to comply and start explaining its beliefs, its policies, what it provides, what it doesn't, when it refers people or says that they're not the right fit, etc. So this exchange happened. A few days later, apparently Michigan withdrew the approvals for Catholic Charities to participate in these programs, and there was really no explanation. So again, it's early in the lawsuit. Michigan will have a chance to actually provide more detail about its justification for its actions, but for now, the state hasn't really provided anything. So all we have is this presumption that Catholic Charities' religious beliefs on the relevant issues regarding the sanctity of life, sexuality issues were the apparent reason for withdrawing approval to participate in these funding programs because we have nothing else to go on. And I just want to say, if that is so, then I think Catholic Charities is on pretty solid ground, especially considering two precedents set in recent years by the Supreme Court, right? You have Carson v. Macon, which is pretty clear that if you have generally available public programs that are funded by the government, you can't exclude an organization based on its religious character. That's one. And then the other one, Wisconsin Catholic Charities, the case that was decided last year, is pretty clear that if you do have certain exemptions or benefits for religion, then to distinguish between, well, this kind of religious organization can take advantage and this kind can't, right? In Wisconsin Catholic Charities, it was, what did they try to say, that you can't get the unemployment tax exemption unless you're a religious organization that either proselytizes or only serves members of the same faith. And that was a unanimous opinion where I think it was Justice Sotomayor, right, who said, like, that's an establishment clause issue. You're picking which religions you favor, and you're like explicitly disfavoring certain kinds of religions. You can't do that either. So the way I see it here is if it is indeed religious animus of some kind behind these withdrawals of funding here in Michigan, then you either have a Carson problem that you're just discriminating against religion, or you have a Wisconsin Catholic Charities problem because you're discriminating against some kinds of religion but not others. Either way, it looks pretty good unless more factual evidence comes out that surprises us. So I think I'll end there and just say thank you to our friends at ADF. I looked at the filing and saw two of our ADF friends, David Cortman and John Birch, who's a current GCP fellow in our lawyers program. And both lawyers have been guests on this podcast before. So thank you to you both for spearheading this complaint. Hopeful that this lawsuit will lead Michigan to back down quickly, but Michigan has been pretty good at digging their heels in on these religion cases in past years, and a lot of things we've featured right here on this podcast. So wouldn't be too surprised if this lawsuit drags out a bit and perhaps even goes up on appeal and becomes a precedential case. But as all of the cases that are ongoing, we'll be watching this one closely.
It's surprising too to see, maybe not from Michigan specifically, but we see this, I think, again and again with whether it's school districts or state governments that are distributing some sort of funding or something like this, where they're really targeting, or at least seem to be targeting, the charitable work of religious organizations, which is only harming their own citizens, whether that's the state or the students of a school district or something like that, especially when these charitable organizations are so responsible for providing most of the relief programs or support programs or the aid that's available to a lot of the individuals living in those areas. So it's a bit bizarre to see them removing funding from what is potentially one of the only avenues of receiving some kind of, whether it's treatment or medical support or something like that, from the area. It's sad and it's not in all cases so surprising, but it's a bit ironic also that the states are kind of ultimately they're attacking the religious organization, but really harming their own people.
Yeah, that's a great point. It's funny, like it would be, like you said, it's not surprising because it seems that if you hold to certain religious beliefs, you're under suspicion regardless of what you do. But yeah, I would be less surprised if it was like a pro-life advocacy group whose main job was like evangelizing women outside of abortion facilities and trying to convince them, like, because there you have like an enemy of on an ideological issue from opponents of religion, right? But this is like Catholic Charities is helping drug addicts, counseling women who are often vulnerable to like sex abuse and trafficking, even like resettling migrants, I think is one of the things that this Catholic Charities is spending resources on. So yeah, not the typical target of these kind of attacks usually.
Exactly. And speaking of similar situations, we can move over to Maryland, where we have a school district, a county school district in this case, targeting what seems like at least targeting a Maryland school teacher and firing her essentially for her unwillingness to use false pronouns. So Kimberly Polk was a substitute teacher who worked in Montgomery County Public Schools in Maryland in the 2021-22 school year. And this is just on the northern border of DC. So we're pretty close to the heart of the nation. When she attempted to complete her mandatory training for the next school year to continue serving as a substitute teacher, she learned that employees were now going to be required to do two things. The first was to use preferred pronouns of the child, even if those preferred pronouns were inconsistent with their biological sex. And the second, and slightly even more shocking thing, is that she was required to keep that information secret from any and every parent or guardian of the child, unless the child gave consent to share that information with their parents. So you have sort of a double-pronged issue here. As a Christian, Polk had issues with both things, but principally with that use of a preferred pronoun, the requirement to affirm a child's chosen sex, rather than to recognize that every person was created by God, male and female, and that you cannot change that biological sex. Polk was willing and expressed that she was willing to use a preferred name of a child if they wanted to go by something else, but that she would use the name in order to avoid using personal pronouns at all, but felt that she couldn't lie to the child by using the wrong sex pronoun, essentially. She requested a religious accommodation to this general policy from the school district and was ultimately refused. And because she was refused that, she was not allowed to continue her service as a substitute teacher in the school district at all for the following year. So obviously this happened a couple of years ago. At the end of June of this year, ADF, along with a few other law firms like Claybrook, Gammon and Grange, and National Legal Foundation, filed a writ of certiorari asking the Supreme Court to consider this case because it had just come back out of a divided panel on the Fourth Circuit, which introduced some interesting legal questions. So the writ for cert asked the Supreme Court to consider two key questions. The first is, when public schools try to force teachers over their religious objections to use pronouns inconsistent with a student's biological sex and to hide that information from parents, does Smith apply, Employment Division versus Smith, and foreclose heightened scrutiny under the Free Exercise Clause? And then secondly, do public schools speech clause when they compel objecting teachers to adhere to such a school policy? So you have two First Amendment but separate clause issues here, both really interesting questions presented for the court. And I think the facts of this case make it sound like it's just another version of some of the cases we've seen recently. I'm thinking especially of the Mahmoud case, but there are some interesting differences here which could make this case one that's appealing for the Supreme Court to take on cert. Of course, it has similarities to Mahmoud. Teachers can't be forced to endorse a specific kind of policy from the school district, especially from the Mahmoud case. We see when the parents are intentionally left out or some kind of opt-out program is not provided, something like that. But here you see gender identity policies intentionally driving out traditional religious beliefs about sexuality entirely. And not only because they're teaching something in a curriculum or they have a certain section of a curriculum, but also because they're removing any person who won't adhere to a specific gender identity policy from the classroom in general. And the petition notes that the Supreme Court has confirmed that deceiving parents about a school's attempt to socially transition their children likely violates the Constitution. So this is one of those areas where you see this go a step further because the teachers are being asked not to tell the parents that their child is attempting to socially transition, at least in the school context, right? So you're kind of coercing teachers to serve in a particular capacity. And that's what takes this, even further. The case could also be interesting for some other reasons. So the Fourth Circuit created a circuit split by their ruling at the appellate level because they held that a plaintiff can defeat neutrality, this is the Smith question, right, only by pleading overt religious hostility or animus. So if the plaintiff cannot argue that this is overtly religious, hostile to religion, but that instead it's like some general policy, then they can't succeed on that ground, which other circuits have disagreed about. Also, we see that these rulings in general reflect a broader trend among circuits to read all in-classroom teacher speech as government speech, which the petition argues runs headlong into the Kennedy case, Kennedy versus Bremerton School District. So you have an interesting question there of, does this implicate exclusively or only government speech, or does it also implicate a teacher's own protected speech? Where's the distinction in the actors there? And does that teacher have a separate free speech right that wouldn't even necessarily trump some kind of governmental speech right, but we would just attempting to acknowledge that it exists in the space, along with whatever a school district policy might be. So you have some interesting legal movements behind this case, which I think make it more fascinating than just saying it sounds like all the other things we've seen with school district policies lately. So potentially a really interesting one for the Supreme Court to take in the upcoming term. If they don't, they'll leave a really interesting circuit split on the table. So we'll be curious to see if other circuits weigh in on this in the next term, or maybe even as just things continue moving in a lot of school districts across the country, if you keep seeing courts having to ask and answer these kinds of questions. And the last thing I'll say about this is I'm not 100% sure what the policy was exactly that the teachers were being asked to essentially affirm, but I imagine that it was in place for every teacher and every grade in the school district that they operated. So this would give even very, very young students, like first, second, third grade, the quote unquote freedom to make this decision for themselves without considering the potential harm that brings, not only long term for those children, but even in the immediate. We don't let children who are very, very young make lots of decisions of this caliber in any capacity. And I think people even who would maybe agree with gender affirming policies would say, oh, of course, there are other things that I would never let my child or a child make a decision about because of X, Y, or Z reason. They're not developed enough, they're not experienced enough, whatever the case may be. And yet in this instance, you're saying that the child as young as a first or second or third grader has the capacity to make that decision for themselves and can change it whenever they want. And then we won't even tell their parents that they've done that. So a really bizarre understanding of what the capacity of children is to do, because they're the ones in this policy that are driving the decision, not simply the school district saying we're affirming it by teaching a certain curriculum, but also we're affirming it by encouraging students to make a decision for themselves. So it leaves a secondary point there too.
Yeah, that last point is an important one. There's obviously the problem of the religious and free speech issues when you're forcing pronoun use and preferred name use and all of this stuff. You have the separate issue when it's being done behind parents' back and undermining parental rights. And then I feel like there's a bigger issue that we're slowly, maybe not so slowly, chipping away at, like you said, these just basic understandings of children not being able to make free choices on certain issues, where I wonder where that goes, because if you have minor children who can choose to socially transition, to physically transition, to do all these awful things, I mean, we have a large number of things that we regulate children can't do without their parents, right? You can't get piercings in a lot of places, you can't get tattoos, you can't see certain movies, you certainly can't buy like alcohol and tobacco under a certain age. Like, I don't know, if we start this idea that children have the freedom to make decisions and that parents don't, and it's at younger and younger ages, I have a lot of concerns about that general ability of parents to protect their children from the fact that children are not fully formed adults and can't make these decisions freely or knowingly. I also just think I hope this looks like a pretty good case. I think it's unfortunate. I was really hoping that the Supreme Court would take Foote v. Ludlow in the last term, but they did deny cert after like putting it off in conference, I think like 12 times or something. And so I'm curious what's going on here because I thought the Foote case was actually a really strong one because of the facts and what the active steps parents were already taking to try to deal with their child's gender dysphoria issues and the school still doing their own thing and not informing them. I thought it was a really good case. And so I don't know if the court's just looking for different facts. I hope that it is not the case that the court just decided Mirabelli versus Bonta and is not going to take another case on this because I think circumstances on the ground will probably force that option off the table because you're already hearing murmuring in other states that, well, Mirabelli, that was a shadow docket case. That was on the emergency docket. It's not binding. I mean, I don't think that's correct. And it wasn't just a simple emergency docket order. It had an opinion written. So how school districts and states can just ignore Mirabelli is a little bit baffling. But I think the reality is because it's an emergency docket case and it's the only one we have on it, I think the SCOTUS will eventually have to take another case and have a full briefing, full merits case. And for the reasons you pointed out, there's a circuit split now brewing. This is a really good case to deal with not the parental rights side even so much as the teachers' right, free speech and free exercise rights. I think that's an important thing, and I hope that this will be the next case to move this issue forward. All right, so now we'll finish up in the Supreme Court. I don't want to do too much analysis because I think most of our listeners, this was a hot case. Everybody was watching for this. This and Trump v. Barbara, right? The birthright citizenship case came out last week on the last day of the decision releases from the Supreme Court. So these two cases, they were heard and decided together. West Virginia versus BPJ was one, and Little versus Hecox was the other. And these, again, I'm sure everybody listening to this is already aware of these, but these were both Title IX and equal protection challenges to state laws that prohibit men or boys, depending on the school, from competing in women's or girls' sports. So, brief summary, Supreme Court held that Title IX allows schools to maintain separate men's and women's sports teams based on biological sex. Justice Kavanaugh wrote the opinion, which held that the term sex in Title IX cannot plausibly be interpreted to refer to anything other than biological sex. I will just pause and say that it's a good opinion, but it's astounding that we have to have these. Like, this is such a common sense thing, both in terms of just social and physical reality, but also like the law. This is such a modern bending of our laws that we shouldn't really need the Supreme Court to weigh in on those, but I will stop my digression and just go on here. So Justice Kavanaugh's majority opinion explains that, not surprising to anyone, that at the time Title IX was enacted in the 1960s, sex referred to biological sex and not gender identity. Of course, nobody was talking about gender identity. It didn't really exist as a social construct, let alone as a legal category. But additionally, the opinion states that sex must refer to biological sex because Title IX's whole regulatory framework explicitly permits the separation of sports teams based on the inherent differences between men and women. There's also an equal protection clause holding that I will get to in a moment. So the two laws at issue here, they're essentially the same in the main aspects of what they do. West Virginia's Save Women's Sports Act and Idaho's Fairness in Women's Sports Act both prohibit males from playing in women's school sports programs. So, as I said, the Supreme Court was pretty clear. I'll quote here, Title IX allows schools to provide separate women's and men's sports teams defined by biological sex, and West Virginia has permissibly maintained female sports for biological females consistent with Title IX. Sex for Title IX purposes can't be read to mean anything other than biological sex, and so the claims of boys who identify as girls here doesn't violate the prohibitions on sex discrimination in Title IX. Again, it's hard to get through these because this is so patently obvious. But one thing I'll note is that the equal protection clause, it wasn't dealt with a final nail in the coffin, but I think there was progress made here. That The Equal Protection Clause does not create, strict scrutiny categories or heightened scrutiny categories for people who identify as a sex other than their sex. Although Justice Thomas wrote a concurrence to explicitly state that this should not even be on the table. I'll get to that in a minute. But on the majority opinion holds that the Equal Protection Clause in the 14th Amendment does not prohibit states from excluding all boys from girls' sports, including those who identify as girls, even those who have taken cross-sex hormones, etc. So this is an important thing to note in this case, is the both Hecox and BPJ. BPJ is an abbreviation because that boy is a minor. But they were basically arguing that they acknowledged that these laws were not facially unconstitutional because there is a difference between boys and girls, men and women in general, that would warrant this separation on the basis of sex in sports. But their basic argument was that, but for boys like us who have taken these, puberty blockers, cross-sex hormones, the advantage of boys over girls is mitigated to the point where just taking these hormones basically satisfies the state's interest in justice and fair play. And the court rejects this for a number of reasons, but I'll read from the opinion here. States are not required to conduct an individual by individual comparison of the physical and athletic capabilities of all biological males in order to satisfy immediate scrutiny. Under the immediate scrutiny test, the validity of the regulation depends on the relation it bears to the overall problem the government seeks to correct, not on the extent to which it furthers the government's interest in an individual case. And I think this is a really important, just common sense thing to point out, is that, look, if you have this separation, boys play boys sports, girls play girls sports, period, you have right? This is it's an important category error not to make. That what we're talking about is general statistics in the aggregate, right? In the aggregate, boys have more testosterone than girls. Men have more testosterone than women, so they have more muscle mass. They have denser bones. It makes for unfair play. Now, those are general statistics, right? So if the men are from like here to here, women on average are from here to here, there's going to be some overlap where there are some girls who have more testosterone, more muscle mass, more bone density than some boys. That's not the point, right? The court, or the governments in this case, do not have to prove that like it would be unfair competition if any boy competed against any girl. No, like the overall issue, that's sufficient. If the government is saying like boys in general cannot compete with girls in general because boys in general are stronger, bigger, etc., and it's a safety issue, it's a fairness issue, period. Intermediate scrutiny does not require the government to look at every single boy and determine whether that boy could in fact play fairly in girls' sports. That's nobody thinks that's a reasonable. Well, I shouldn't say nobody, because clearly BPJ and Hecox both think that's the way that this analysis should go down, but the court was having none of it. And so the court says pretty clearly, intermediate scrutiny permits a sex-based classification that, as here, is not invidious, but rather realistically reflects the fact that the sexes are not similarly situated in certain circumstances. There's a lot that is of interest in those couple of sentences. I will also note that it was not at all clear that intermediate scrutiny definitely applies. There's some back and forth in the opinion that says, we haven't really gone there on transgender classification, whether this is like, is it really sex-based discrimination that warrants intermediate scrutiny? Is this an unprotected class that would just warrant rational basis? Court does not, unfortunately, answer that in this case. Maybe it wasn't quite the right case to do it, but the court kind of avoids that question and says it doesn't matter. Under either rational basis or intermediate scrutiny, there's nothing wrong with what the governments are doing here. So that question is kind of left as it is. So one other point I'll make is that, which I was glad to see, the court rejects this idea that, first of all, they don't have to analyze every boy that's on like puberty blockers to see if he could compete in women's sports. But they also challenge, like, this is not settled science, and this is worth pointing out. Let me see if I can find the quote. Yeah, so they go through at length why it would be an impossible task for judges to perform on an equitable basis when a boy could safely and fairly compete with females, but they also say like this is not settled science. The state governments are right to say like doesn't matter if you're on puberty blockers or hormones or whatever, like there's nothing conclusive to say, oh well yeah, you can compete fairly with females, right? These hormones have made you exactly the same as a woman. There's actually good science, and again, I'm not a scientist, but for what it's worth, I have read a little bit into these starting when Scarametti came down last year that in fact there is a good body of evidence that even in the womb, the differences in how boys are formed versus girls will lead to differences in the development of muscle and bone mass to the point where puberty blockers around the time of puberty are not just making boys into the equivalent of physical girls in their sport playing abilities. So anyway, the court does point that out and say, this is not settled science. Don't tell us that this is settled science, but also even if it was, this is generally acceptable. There's no reason for the states to have to do this analysis. They are on solid ground by just letting girls play girls sports. I won't go on. I could, but I would just say two things for those interested. I'll kind of limit my commentary for a reason here, but for those who are deeply interested in these issues, I would certainly recommend Justice Thomas's concurrence, which is like 3 paragraphs where you can read it for yourself. But to summarize, he basically says, like, I agree with everything the majority wrote, but I want to make 2 points. One, boys who identify as girls are boys. They're not transgender girls. Like this, there's no suspect class. They're not a separate class of transgender people. They're boys, which it was, yeah, he came pretty hard on that. And the other thing he said was, yeah, this is not a class, you know, they're not a class, they're not a separate sex. This is actually like a psychological, like a psychiatric problem. This has long been the understanding. Gender dysphoria is not something that warrants, you know, special treatment under these non-discrimination laws. So again, a couple paragraphs, but anytime Justice Thomas decides to write separately, even when he agrees with the majority, it's worth reading. I would also encourage the curious to read Justice Gorsuch's concurrence, where he attempts to reconcile his opinion in Bostock that sex-based discrimination under a different title of the Civil Rights Act, right? That basically it was right to say that men can wear dresses in the workplace and that's protected by the Civil Rights Act, but somehow boys competing against girls in sports is unfair and is not allowed. So anyway, I think it's a pretty, frankly, I think it's an ineffective attempt to distinguish. If I were him, I would just disavow what he did in Bostock, but clearly nobody asked me what he should write. But I think it is worthwhile to read because Bostock was kind of a watershed moment for a lot of people in the broader like conservative legal movement. And so this concurring opinion is worth engaging. So I guess I'll leave it here. Just kind of applaud the court for making a decision that should be common sense. Boys and girls are not the same. Boys competing against girls in sports is unfair. And it's not only fair, but at the heart of sex discrimination laws like the Civil Rights Act to give girls an equal playing field, literally, in school sports programs. So it's really like, not only should this not be part of the Civil Rights Act and of sex discrimination law, but it's a complete undermining of it if you're going to allow boys to use gender sex discrimination laws to take away the ability of girls to have their own sports. The whole thing is very ironic and kind of tragic. So this case at least opening the door for states to just keep the sexes separate in sports is a welcome outcome.
I'll leave us by just echoing what you said there at the end, both for Justice Thomas and Justice Gorsuch. I think Justice Thomas's concurrence is a great read, especially to consider where we might be going next. Obviously, this is likely not the last time the Supreme Court is going to have to weigh in on this kind of issue or a related issue. And we might be moving in the direction of what Justice Thomas is raising as like the next legal part of this legal problem. So it's good to familiarize ourselves with that. And then also, I just completely agree that you should read Justice Gorsuch's concurrence to see the bizarre way he attempts to rectify this case with Bostock. And then maybe before you do that, read just the opening parts of the majority opinion. As you laid it out, Frank, it also just almost immediately sounds in conflict with Bostock. Of course, you're considering different titles, but very similar language. So an interesting statutory interpretation exercise potentially for law students that want to see different legal perspectives at work too.
Yeah, that's a great point. I guess the best steelman case you could make for Justice Gorsuch trying to distinguish these here, right, is that in this case, there's a more compelling government interest because allowing boys into girls' sports can actually hurt girls. Whereas if you're only looking at like physical harms and things like, okay, if a man is wearing a dress at work, like not the same case, so there are no women being, given concussions and stuff. That's about the best I can do. So I can see different scenario to justify government action. But again, the reasoning seems to be extremely in tension, if not open conflict between the two opinions. But we will, I suppose, leave that for another day. Actually, no, last point I have to say, I think this is real, like you said, no, because you made a really great point about Justice Thomas's concurrence. It's brief, but he doesn't do anything flippantly or by accident. He's very careful. And I think you're right. It was really important to leave another, piece on the trail here because we saw it last year in Scarametti where Justice Amy Barrett wrote a concurrence to say explicitly transgender status is not a suspect class under the Equal Protection Clause, period. And then Justice Thomas, I think, is kind of keeping that line alive. So I agree with you. I think the case is going to come. This one was more about the Civil Rights Act. They were able to dispose of the equal protection claim without addressing that question head on. But my guess is in the next couple terms, that case is certainly coming where the Supreme Court will have a direct question of is transgender status an equal protection, like a suspect class, intermediate or strict scrutiny. And we actually don't know what all 9 justices think about that. So glad to see breadcrumbs from at least a couple of them. And I will end by saying that I know there are a lot of political calculations going on and we're approaching midterms, but my ardent hope is that Justice Thomas dies on the Supreme Court. Like, I hope he will stay on the court as long as he is possibly able. I don't believe in just swapping out one justice for another under a Republican admin just for the sake of a younger pick. I think he's just such an important thought leader on the court. And yes, I hope he stays for as long as he possibly can. And unless you have anything else, I think that's a pretty good note to end on. All right. Well, thank you all for joining us for another episode of the Napa Legal Podcast. We hope you'll join us next week as we continue to highlight and discuss the most important issues that affect religious liberty and the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you all.